के सारे लेके आप हमें ये चार्जशीट करना चाह रहे हैं कि सुप्रीम कोर्ट ने इन तमाम को देखने के बाद जो कॉम्पिटेंस नहीं थी उसने लॉ बना दिया और अब हम उसे लेजिटिमेट कर दें. You want to invoke us the doctrine of necessity to legitimate this law?
No, sir. No, sir. To the contrary.
I think. I think.
मैं अगली बात जरा कंप्लीट कर लूँ.
Mr. Attorney General, I think हमें थोड़ा सा हौसला रखना चाहिए सुनने के लिए तनकीद. I don't think you use the word charge sheet.
I have not.
You are simply stating a fact, and we should have the patience to hear your submissions. Your submission is, from what you have just commenced by stating, that 184.3 may have done some very good work as well, but 184.3's consequences have also been, I don't want to use the word disastrous, but maybe not so good. So you're just stating that Parliament does not have to mention each and every case, but this is the cumulative understanding. I mean, you don't have to spell out everything. So Miduzdin Khan was not 184.3, etc., but these cases were. So you are just stating a fact, and we should be sort of have the wherewithal to accept it. I mean, we were a council at some stage, and we are judges now, and we are citizens always. So if someone is stating a historical fact to build the argument why 184.3 may have been given a right of appeal, so let us hear him with patience. And if you don't agree with that, by all means, write judgments whichever you want to, but at least please continue. I mean, otherwise we'll be forever. I mean, you didn't do this thing. You are saying we did it, and you're just pointing, showing us the mirror. Fine, I have no problem to show me a mirror about all the judgments I've passed which are wrong. I have absolutely no problem. I would say thank you. I may learn from it, and I won't commit the same error or mistake again. So please proceed.
Mr. Attorney General, the question still remains, which I've already put before you, whether the court did good or whether the court did bad, and beauty may lie in the eye of the beholder, and there may be people who say this was good and that was bad and that was not so good and that was not so bad, and we can carry on ad nauseum. This is not a debating society. We are not sitting here to receive a public lecture from you, sir. You are Attorney General. Kindly tell us what is...
If there was a remedy of appeal.
Sawal sun lein.
If there was a remedy of appeal.
What does that have to do with the...
These consequences could have been averted.
बात तो सुन लेना. What does that have to do with the legislative competence of the
I have, as I stated, my lord, I have already made submissions to it. I am referring to what yesterday Justice Hilali...
There is legislative competence, तो बात खत्म हो गई.
जी.
आप हमें ये
necessity दे रहे हैं. ये इसलिए जरूरी है सर कि ये आपके पास अभी not long ago record date के ऊपर under 186 you had to come and protect what had happened.
Then the question that my learned colleague has asked you, that becomes relevant. आप हमें बात कीजिए लेजिस्लेटिव कॉम्पिटेंस की. आप हमें कन्विंस कर कीजिए कि आपके मुताबिक यहाँ कह दें जी वो सब गलत कह रहे हैं, बात खत्म हो गई. I don't have to do anything. Onus lies on them. You kindly tell us about legislative competence.
कल जस्टिस हिलाली ने एक कमेंट किया था, एक ऑब्जर्वेशन थी उनकी. उन्होंने कहा कि 184.3 जब एक्सरसाइज हुआ.
Mr. Attorney General, I've been a counsel more years than I've been a judge, and I would always prefer that the judges let me complete my submissions. They may not accept my submissions, hear my submissions, and discard my submissions, but certainly your right of making a submission, I think, otherwise we don't need to give you a notice, we can decide the matter ourselves. So please proceed in your own way.
While concluding my
दो चीजें देख लेते हैं जी. ये तो यहाँ तक everyone agrees that there were certain issues regarding 184 which agitated or which disturbed the executive and the parliament. Fine. Point taken. Second point, the law that you enacted, that law, everyone agrees कि ठीक है, law में कोई ऐसी चीज नहीं है, बाज यहाँ होगी, लेकिन वो law, no one said कि ये law जो है ये किसी तरीके से infringe कर रहा है आपके fundamental rights को as such, directly. असली जो main चीज आपने एड्रेस करनी है वो है उस लॉ की आपकी जो लीगल कॉम्पिटेंस है, उस लेजिस्लेटिव कॉम्पिटेंस. आप प्लीज उस पे आ जाए.
My lord, I'll come to the question that you had raised before the proceedings.
आप अपने आर्ग्यूमेंट्स करें.
My lord, I have
my question, take it at the end. पहले अपने आर्ग्यूमेंट्स खत्म करें, like the चीफ जस्टिस just said कि भाई पहले उनको तो बोलने दे, आप जो आप बोलना चाहते हैं प्लीज बोल।
बल्कि सारे क्वेश्चन का जवाब आप बाद में दे दें, पहले अपने
आगे
My lord, as far as provisions other than Section 5 are concerned, with regards to practice and procedure, I have submitted that the competence is drawn from Article 191, read with entry 58, and of course together read with 142A. 191 in itself acknowledges, recognizes Parliament's power to make laws with respect to practice and procedure, and the term law used in 191 does not in any manner exclude an act of Parliament.
ये जो आप अगर एंट्री 58 को देखें, इसमें एंट्री 58 में आप किस उसमें आ रहे हैं, विद इन द लेजिस्लेटिव कॉम्पिटेंस ऑफ मजलिस शूरा,
yes,
or relates to the federation?
First part.
Okay,
and
so your reliance on item 58 is directly dependent upon or flowing from your arguments that 191 confers legislative competence.
Yes.
Okay, point taken.
So this is the conclusion or some of what I have submitted on as far as legislative competence with respect to matters related to practice and procedure are concerned. Now, and then comes Section 5, which is a substantive right of appeal, which has been conferred, and which obviously, at least in my my submission is that for that we have to go to entry 55, and entry 55, my lord, does two things. It empowers the Parliament to legislate with respect to jurisdiction and powers of all courts with respect to all the matters in the list, and to such extent as is expressly provided by or under the Constitution. But as far as Supreme Court is concerned, it empowers the Parliament to only enlarge its jurisdiction and confer supplemental powers on it. So it does deal with Supreme Court's jurisdiction and powers, but only to enhance them, not to curtail them. But as far as other courts are concerned, both things can happen, subject to what is provided by or under the Constitution, the language of the Constitution.
So once that jurisdiction has been enlarged, that act cannot be repealed.
My lord, I was thinking about the question
cannot
that
be
you
taken away.
You mean to say that enlargement of jurisdiction includes right of appeal?
Yes, sir. Because this is the appellate jurisdiction of the Supreme Court, which exists in the Constitution, the appellate jurisdiction. It is that jurisdiction.
In fact, the
which has
original
been
jurisdiction has been enhanced. No? Under Article 184(3) is the original jurisdiction.
Original jurisdiction.
It has been enhanced by enlargement.
So my submission and my response to your question, my lord, is that nothing in Article 184 or 185 provide any extent to which they can be enlarged. Because they do not so there is no bar on the Parliament to the extent to which the jurisdiction can be enlarged.
Is there any limit of enlargement because the right of appeal has been given with retrospective effect? There is no cut-off date and it is open-ended. This question was also asked by me to Mr. Salahuddin, where it was not responded.
Mr. Attorney General, you have not given the details of express authorization that requires your...
My lords may note Article 212, Clause 1, subclauses A, B, C, and then read with Clause 2 of Article 212 with respect to administrative courts. It does both things. It provides to the extent to which those courts will function, the powers those courts will exercise, and then in Clause 2, it then places limits as well, that no other court shall then exercise such powers. Thus, what this Clause 2 does is, it places limits on the Parliament's power. The extent of authorization with respect to administrative courts is thus then covered under Clause 1, A, B, C, and then
Clause 2. Related to the administrative tribunals and courts, how this
is all courts, sir,
helpful to you with regard to Section 5, which has been introduced under the new Act?
वो अब इस पे मैं इसको जरा conclude कर लूँ इस बात को आगे. As far as article अब territorial jurisdiction, for example, of the High Court जो है वो extend हो सकती है.
Section 5 is substitute of 185.
जी मैं उस पे आ रहा हूँ. मैं भी वो वाला part explain कर रहा हूँ जो जो सवाल था आपका कि कहाँ वो बताई हुई है बाय और एक्सटेंड,
नहीं वो एडमिनिस्ट्रेटिव कोर्ट्स की बात
मैं अभी जरा
वी आर टॉकिंग अबाउट द सुप्रीम कोर्ट
जी जी मैं उसी पे ही वापस आऊंगा ना जब मैं ये कंप्लीट करूंगा
विद रेफरेंस टू अपील।
जी जी दूसरी जो एग्जांपल है, दूसरा इंस्टेंस नॉट एग्जांपल, दूसरा जो इंस्टेंस है 192 क्लॉज 5
और भी ले लीजिए, जब आप 184(3) की अपील देख रहे हैं और लेजिस्लेचर ने या पार्लियामेंट ने महसूस किया कि यहाँ पे एक राइट ऑफ अपील होना चाहिए, तो फिर 184(1) की क्यों नहीं अपील दी गई, उसके बारे में क्यों नहीं सोचा गया?
जी
Why only 184(3)?
I'll address this. आप आर्टिकल 192 क्लॉज 5 देखेंगे।
Mr. Attorney General, to add to that, if your argument was taken on its face value that enlargement is unrestricted and there is no limit given, then do you think by a legislative instrument 2 other appeals can be provided under 185? Let's say उनका जी एक अपील जो है वो 3 मेंबर बेंच ने डिसमिस कर दी है, उसके अगेंस्ट एक और अपील होगी जो 5 मेंबर बेंच सुनेगा, और वो अगर डिसमिस हो जाती है तो एक और अपील होगी जो 7 मेंबर बेंच सुनेगा. बाय डेफिनेशन इफ देयर इज नो लिमिट then you are just enhancing, and you are enhancing through a legislative instrument which finds no support from the Constitution.
Well, noted, my lord. I'll come back to this question. My lord, back to clause 5 of Article 192, which permits through an act of parliament extension of High Court's jurisdiction to areas beyond the provinces, which are not part of the province. So that is also...
You have already argued this point.
Ji. So that this is also an instance where the extent is provided by which the express authorization is provided. Now, as far as enlargement is concerned, now if I may, my lord, you have a question?
No, I'm just waiting for the answer of retrospectivity.
Ji. Oh, there are so many questions and there is so उसमें problem ये होता है my lord कि उसमें फिर कोई एक question miss हो जाता है and that is unfair to lordship and leadership.
एक मिसाल मैं देता हूँ एजी साहब, बलूचिस्तान में पहले प्रोविंशियली एडमिनिस्ट्रेटेड ट्राइबल एरिया होते थे जो अभी अमेंडमेंट के तहत खत्म हो गई, तो हाई कोर्ट की जुरिस्डिक्शन वहाँ तक स्पेशली एक्सटेंड की गई थी. Initially there was the High Court had no jurisdiction, then subsequently it was enhanced.
उस पे तो कोई बार नहीं है.
तो वो एक्सटेंशन उस सूरत में होती है हाई कोर्ट. जी जी जो आप कहते हैं हाई कोर्ट की jurisdiction to the areas which does not fall within the province, उन एरिया तक वो jurisdiction रहती है.
Yeah, so this is an authorization under the Constitution through an act of Parliament. My lord,
ये पहले retrospectivity की जरा जवाब दे दें.
पहले retrospectivity to enlargement.
Yes, please continue.
My lord, have I addressed your question? I have not.
I'm in no rush. Take your time. Take your time.
My lord, my lord, as
Mr. Attorney General, answering a question and us finding your answer appropriate are two satisfactory are two different things.
Two different things.
So we may not agree with you.
Yes. I'm just hoping that I can persuade the majorities. That's the
Should hope to persuade everyone.
No, I want to persuade everyone, but because we are in full court.
That's a very lawyer's remark. Majority.
But after arguing for all of us put together. No, I understand.
As Attorney General, you should say I should be able to convince the whole.
No, because on full court, I have to go back to leadership. So it is part of that. Retrospectivity, sir. Now, my lord, I see the concern that my lords have on applying this law retrospectively and thus opening sort of doors to perhaps a lot of litigation. My lords, there are several cases, many cases, which are no longer live issues.
Before you even address this question, does this law state explicitly whether its application is prospective or retrospective? Does it state so?
Subsection 2 of section 5, my lords.
Yes. Ji padhiye.
Is the right of appeal under subsection 1 shall also be available to an aggrieved person against whom an order has been made under Clause 3 of Article 184 of the Constitution prior to the commencement of this Act.
Prior to the commencement. So its application is retrospective. ठीक है.
So,
and it excludes any order passed under Article 188, where a review has been decided.
Does it attend to what my Lord is observing?
my Lord,
No, does it, first of all, before your opinion, does the statute say anything?